My lady, can I say we're very grateful to the court staff for addressing the problem of overheating, but I see that it may affect some of us.
I was freezing this morning.
Yes, I'm
and I remain freezing, so there we go.
I'm going to turn, if I may, to the question, what does the contract attribute to the day's strike pay in the present case? You've seen in our case various, as it were, general points, that we submit there's no general principle that an employer pays for all of the activities associated with a given job, which may or may not be regarded as work. And secondly, that it behoves both parties to a contract of employment to agree what is being paid for.
Well, if the employer doesn't pay for them, is the employee entitled not to do them? That would seem inconsistent with the principle in Miles and Wakefield.
Well,
it certainly seems inconsistent with what Lord Templeman said in Miles and Wakefield.
It's in our submission, it's permissible to have a situation as here where there is a contractual obligation to do such duties at undirected time as are necessary to supplement the directed time, but for it to be agreed that they are not being paid for.
So basically you're saying that the contract may provide that an employee has to do certain things, but what the employer pays is not in respect of those things. Is that what you're saying this contract provides?
What we're saying is, what we're pointing out, for example, is that the contract already doesn't provide for a direct correlation between work and pay. We accept that the contract provides for 13 weeks' pay despite the fact that no work will be provided. And we also point out or submit that the contract provides for undirected time to be performed, but not paid for.
So, picking up Mr. Siegel's point this morning, if a teacher was to say, I'm not prepared to write school reports in undirected time, on your case, he gets fully paid.
On our case, he's entitled to be paid, yes, subject to the following 2 points. There may be, because he's in breach of contract, in principle, a right to cross-claim damages, but I accept there would be difficulties of proof. Secondly, if the non-performance of the undirected duties meant that, in effect, the directed duties were being partially performed, then it would be open to the employer to say that it was not prepared to accept partial performance of the directed duties, and then not to pay for the directed time.
Mr. Linden, can I be clear about this? You said before lunch that as far as Saturday and Sunday were concerned, the sums payable by the employer were nil. I think that's what you said.
Yes.
So if it were apparent that it was impossible for the teacher properly to fulfill the requirements of Appendix 4 within the constraints of time from Monday to Friday, then you say, come what may, Saturday and Sunday don't come into the reckoning as days in which the rate of accrual should be assessed.
My Lord, I accept that. I accept that is the effect of our case. The assumption, not a proven fact, is that it is impossible for the employee to perform their work during the term time days. And I think it was Lord Clark pointed out that it much will depend on what the nature of their job is, the mixture of roles that they have, teaching, supervisory and so on. and much will depend on their efficiency.
Or how prepared they were to skimp, cut corners.
Will you accept that?
Could we just take this a stage further, please? Suppose that among the duties was the duty to go on, let's say, field trips, for the botany class or something like that, which could only be done on a Saturday or a Sunday. Then, notwithstanding that the teacher would be required to do that, nevertheless, because it is a Saturday or a Sunday, it can't count.
Well, I'm grateful for the question, because it may help to elucidate our position. That your first question, if I understood it correctly, my Lord, was about if it were necessary to carry out undirected duties on a Saturday, because they couldn't all be done during the week. But if the question is as to a school trip on a Saturday, I can't say firmly what the answer is, but assuming that that was agreed with the school, then there would be an entitlement to an additional day, which is a point that I'm going to come on to.
Yes, that's a separate point, I see.
So I was on the point that it behoves the parties to agree what's being paid for, A, so that the employer knows whether the employee has done or is doing what they're being paid for, but also so that the employee knows whether they ought to be paid more on the basis that they're doing more than they're being paid for. And our submission is that that is what this contract does. Now, if I can then attempt to develop that submission, the first point is that it is said in terms that no teacher may be required to work on a Sunday, paragraph 26, MS 226. And hence we say, fairly obviously, therefore, salary can't be payment for the Sunday or any part of it attributable to the Sunday. Secondly, coming back to my Lord Gill's point, as regards Saturdays, again, subject to the additional days point, the salary can't be paying for Saturdays. Why? Because the college is closed, but more importantly, from a contractual point of view, if the school or the college requires the teacher to work on a Saturday, they will have to pay an additional day.
Well, if you require him to be somewhere specific on a Saturday.
Yeah.
Yeah.
If it were timetable, for example, that they go to rugby matches against a school with a series of teams, they would have to be paid for an additional day, because that would be directed time performed on a Saturday.
You made this rather neat, prima facie rather neat point about Sunday. If no one can work on a Sunday, how can he be paid for it? But does it depend on what you mean by work? Nobody can be called in to teach on a Sunday.
Yes.
But they've got their other duties, and they may be performing them on a Sunday.
Yeah, I'm just having a look at the term, my Lord. Well, I see the force of the point. If you have it at MS 226, it's paragraph 26. No teacher shall be required to work on a Sunday or bank or other public holiday.
Yes.
But I mean, in many professions, people commonly do have to work on Sundays, just by the sheer necessity of their workload, especially judges. And that's when, some of your best ideas occur to you during sermons, for instance.
We won't inquire further in relation to that. Can I come back to...
I mean, it stands to reason that where the working week, the FaceTime week starts on a Monday, a lot of people will, in fact, prepare for that on a Sunday. so that their preparation is fresh in their mind.
I take that I take that point as a matter of practicality, but my submission is that we're looking at this as a matter of construction, and I don't say, my Lord Wilson described the point as a neat one, but I don't say, well, there's the end of the inquiry. What I say is, and what I'm going to make is essentially a series of evidential points which we submit lead to the conclusion that if you ask under this contract, what is the salary being paid for? The answer is it's being paid for, it's paying for 39.
Well, it's being paid for the directed time and the undirected time. The undirected time may be any time, and you're being paid for both, not just one. See clause 22.
Well, our submission is obviously to the contrary.
But why is it? Just look at it. In addition to the requirements in paragraphs 20 and 21, ... A teacher will work such reasonable additional hours. That's pursuant to his obligations under the contract. So he's doing two types of work on compulsory days and work in undirected time, and there you have it. And it's as simple as that.
Well, that's certainly Mr. Siegel's submission, and
Yes,
what I'm obviously trying to
seems to bear a certain,
persuade you to a different.
it has a certain touching distance to common sense.
Well, my Lord said that to me in various cases, and then proceeded to apply
I
common
agree that
sense.
it's not always acceptable characteristic.
Now,
Oliver once said to me that the trouble with common sense was it suggested the world was flat.
that's right. Now, let me carry on. I'm grateful for the opportunity to carry on. The section, the passage you point to appears in the section dealing with working time, and I'm going to come to the question what is said in the passages dealing with pay, which in my submission is the issue in the present case. I see obviously how the point can be made against me, and forcefully, if I may say so, but I do say that you have to examine the document as a whole, and I'm going to attempt to make a series of points that suggest that actually when it comes to the question of pay, the premise of the contract is that you're being paid for working days, or days when you would otherwise have been working but have been given leave not to do so.
But not for undirected time.
That's right.
So you're not paid at all for undirected time.
That's what I've
You have
accepted.
an obligation to carry it out, but for nothing.
Well, I don't think you say you're not paid at all for it. You simply say that you're paid for it, but the pay is allocated to Mondays to Fridays.
Yes.
That's, I think, where you're going, isn't it?
Absolutely, and also importantly,
It is rather odd, isn't it, that you should be paid on Mondays to Fridays for things that everybody realises you're going to be doing on other days.
well, that you may be doing on other days.
Well, that you're bound to be doing
All right.
another day.
Okay. Well, anyway,
I better try and crack on. So I'm not.
Well, anyway, we have your point. You carry on.
My Lord, that's what you said on the last.
I'm sorry about it. I'll try and think.
Poor Mr. Linden, you must be allowed to carry on.
Trying to think of something more original next.
Let me try and
have to
let me
finish
try
by
and
4 o'clock.
persuade you. Let me try and persuade you. So let's take the point about Saturday working and additional time. Now, obviously, what we say is the contract provides for you to be paid for days on which you are required to be working, can be required to be working the term time days, and that is why, in circumstances where you're required to work an additional day, you receive an additional payment. In the case of Saturday, that is what will happen, and it's implicit in that there's an acceptance that Saturday would not otherwise be being paid for. Now, my learned friend says, well, the answer to that is, of course, there will be undirected time which correlates with the Saturday working. But in my submission, not so. The Saturday working is by definition directed time. They're required by the college to be working on that day. Now, as to what we say about working days as opposed to working hours, we do submit that the agreement is essentially that they will be available to work on term time days. And that is, if you go to page 307, how it's put in Appendix 9. paragraph 4, the appendix to this guidance summarises... I'm sorry, page 307, MS 307.
Sorry.
So the appendix to this guidance summarises the teachers' contractual working time arrangements. These require teachers to be available for a specific number of days and for a total of up to 1265 hours of directed time in the course of the year. So the idea is that during term time days, they are in the language of, for example, the working time directive at their employer's disposal and therefore paid, just in the same way that a junior doctor who has to be on the employer's premises is entitled to have that time regarded as working time, even though they may not be working, they may be sleeping or on call. So that we say is the nature of the requirement to work 195 or days. It's essentially to be available, to be required to work on those days. We also submit that as regards additional days, you should reject my learned friend's argument that the logic of the college's case is that the additional days should be paid at 1/260th. The reason why that is not so is that, of course, the 1/260th fraction is influenced by the fact that the pay covers paid holiday as well. The 10 days are, by definition, directed time during which or part of which the individual is working. Can I turn then to the question of work elsewhere, my Lord Hughes's question, page 232. Paragraph 51 deals with the question of additional employment.
Yeah.
Consistently with our case,
Okay.
the position is that the teacher is required to devote the whole of her time for which they're employed to the service of the college. That is term time days. But they may do other jobs outside term time or outside term time days. If they wish to do that, they must inform the college rather than seek its consent. And such employment must not conflict with the college's interests. So again, we say, consistent with the proposition that the pay is for working days, you're free to take jobs elsewhere outside term time, and indeed at the weekends.
And how does holiday pay fit into that?
I'm going to come to that. As far as holiday pay is concerned, that's page 198, paragraph, clause 2.5. We're looking at Mr. Hartley's contract, but it matters not.
295.
Page 198, paragraph 2.5. Our submission is, if it were the case that the individual was entitled to a daily payment of 1/365th, then it would be unnecessary to specify that they were entitled to paid holidays, because that would be the position in any event. According to Mr. Siegel's case, every day they accrue 1/365th of their pay, whether they are working or not. Now, Mr. Siegel seeks to meet that point by saying, well, this is simply a description of the administrative arrangements, that pay will still come through during the holidays. That, with respect, is wrong, for reasons which I'll seek to demonstrate. But firstly, of course, that there is a statutory minimum entitlement to paid holidays, which this clause is seeking to discharge. It enhances that entitlement by providing for pay at the contractual rate rather than the statutory rate, and by providing for more holiday than the working time regulations require. But the clause is seeking to discharge that statutory obligation. So it is dealing with the right of the individual employee to paid holiday, The second, so Mr. Siegel accurately characterised the question as being whether it's a payment, it's a term that provides an obligation to pay, or simply an administrative arrangement. We say it provides an obligation to pay. If the pay didn't come through, the individual would say, "You have not provided with my holiday pay pursuant to clause 2.5. There's a further point by reference to paragraph 73 of the Red Book, which I'll come back to in a moment. But can we then turn to the question of sick pay? If you've got page 236, the sick pay mechanism, as you will have seen, is built on a concept of full pay for specified numbers of working days and half pay for further working days, with greater entitlement as the employment continues. The premise for those arrangements in our submission is that the individual is being paid for the working days, which we agree, the parties agree, are the term time days, the 195 days. They are not working those days because they're absent for various reasons. And the question therefore has to be addressed as to whether or not they'll be paid, and if so, for how long. But in our submission, that's the crucial point, that the premise is that they're being paid for a certain number of working days. And proceeding from there, arrangements are made as to how many working days they'll be paid for, notwithstanding that they're not working. Hence our submission, further evidence that the parties envisage that the payment would be in respect of working days. Now, if you go then to page 238 and look at the position in relation to holiday, firstly, if I can ask you just to glance at paragraph 71. These, again, proceed from the same premise, that what's being provided is that if the college is closed, in other words, there are no working days, holiday days will not count for the purposes of working out your full sick pay. So if you're entitled to full pay for 25 working days, you will only deduct days in respect of term time days. In holiday time, when you're not required to be working, it's not a working day, the clock will not be running. So again, we make the point that the premise is there are working days for which you're being paid. If you aren't working, the question arises, will you be paid or not? If the day is not a day on which you're working, that will not adversely affect your right to paid sick leave. Now, coming back to the question about holiday, Lord Clark asked me, by reference to paragraph 73, consistently with our submission that clause 2.5 establishes a right to paid holiday, clause 73 provides that if the employee is off sick, but then is restored to health during a holiday period, then they will be regarded as being on holiday rather than off sick, and they will therefore be paid for those holiday days. So on our submission, on any view, there is a contractual right to be paid for working days, and there is a contractual right to be paid for holiday. We submit a statement that there is a right to be paid for holiday is unnecessary on Mr. Siegel's case. In relation to part-timers, we point out that the provisions, this is 223, calibrate pay by reference to directed time rather than by reference to undirected time.
So sorry, which paragraph is that?
My lord, it's paragraph 16G,
What page, please?
page 223. So in common with the other provisions that we've been looking at, there is no provision for extra pay to result from extra undirected time. Extra pay only ever results from additional days' work or additional directed time.
Yes. So,
And that we say is consistent with the analysis of the contract that we propose. Now, one has detected the reaction of certain members of the court to the proposition that undirected time is not paid for as a discrete matter, but with respect, that isn't as surprising as may be suggested by Mr. Siegel. We've offered our analysis of the contract. We pointed out that under the contract there isn't a direct correlation between work and pay. See payment for holidays, payment for being off sick. We've also pointed out importantly, and I know the court has this point on board, that undirected time, marking type activities, preparatory types of activities may be carried on as part of directed time. The contract specifically so provides. That's page 303, if I can take you to that. MS 303.
Yeah.
Sorry, I may have given you a false reference, but
Well, we saw it before.
sorry, it's 308.
Some of the directed time will include time to do some of the duties that are not...
Paragraph 14. Paragraph 14 in particular, page 309. It's important that an appropriate level of non-contact time should be allowed for purposes such as planning, preparation, assessment, which would otherwise be carried out during the teacher's own time, possibly to the detriment of the work-life balance. So I accept that that enables Mr. Siegel to say, well, why would some undirected time be paid for, but not other in undirected time? But what is false about that point is that that's not the position. The position is that certain preparatory activity will be paid for as part of directed time. And what the college has said in its contract with the teachers, therefore, is we are paying you for a certain amount of preparatory work in addition to your teaching, but not all of it. And one can debate where exactly the line should be drawn on the facts of a given case. But you'll have seen, for example, that we would say that this precludes debates. For example, Mr. Pankow coming forward and saying, well, my wife is a social worker. We often discuss student-related issues over the dining table. That might be regarded as work, just as lawyers thinking about a case in the bath, some city firms say is work. I watch the business sections on Newsnight in order to inform my business studies teaching. So what we say is that in common with many contractual arrangements, the contract in the present case has said essentially that a certain amount of preparatory time is paid for by us. Other or additional preparatory time which you carry out is on your own time. You choose when you do it, and as my Lady Hell has pointed out, you choose the extent to which you do it.
Well, up to a point.
To a point, as in all matters. And as I indicated, if you don't do any, and as a result your directed time is deficient and or amounts to partial performance, then there may be consequences, I agree. Nextly, can I point out that in the context of the present case, of course, the analysis we offer redounds to the disadvantage of the employees, and I accept that, obviously. But it won't always be so. The analysis redounds to the advantage. If we were in, for example, a dispute about holiday pay, an individual said, well, I don't think I've been paid the right amount of holiday pay, Mr. Siegel's case would be that the right amount of holiday pay is 1/365th. Our case would be that it's 1/260th. Finally, on the question of undirected time, Mr. Siegel's position is, well, deductions could be made for a refusal to carry out undirected time, but he also said to you, to borrow his words, that there would be mind-boggling difficulties in relation to quantification. We say he's right about that, and that is because the contract does not attribute any pay to undirected time. My Lord, those are my submissions on the contractual analysis. I accept that I have to persuade you, if we're to succeed in this case. Those are the submissions I wish to make on that point. Can I then go on to deal with the other questions in the case? Where does, if we're right on the contractual analysis, where does that fit in terms of the Apportionment Act? Now, the first question is whether there is a principle of equal daily accrual under the 1870 Act. The Court of Appeal, as you know, said there isn't. It appears that Mr. Siegel is also saying that there isn't.
He says there is in some cases and not in others.
Yeah, but that may be what he's saying. But
That's what he's saying.
well, so be it. There's no.
It is in this case, but there are others in which it isn't. Sorry, he's nodding. I hope I understood his case.
Well, so it may be my fault then. The point that I'm making is about the construction of the 1870 Act. The Court of Appeal took the view that it was inherent in Mr. Siegel's arguments that the Act required the principle of equal daily accrual as a matter of statutory construction. Mr. Siegel appears to be agreeing, or appears to be submitting, that the Court of Appeal was right. There is no such principle in all cases. He says such a principle would be wrong. So my point, my lady, is about the construction of the statute as opposed to how it may operate. Now, if we can then go into the Act itself, you've got that in Core Authorities, tab 1. The statutory question, which I'm seeking to address, respectfully adopting the Court of Appeal's approach, relates to section 2, which you have at page 396, and the question whether what is there stated does anything more than provide that in the case of periodical payments, they will accrue from day to day. Does the section provide for the amount which will accrue for day to day? And we submit it doesn't provide for the amount, hence the word apportionable, which raises the question what sum is to be apportioned to each of the relevant days. Now, we pause to observe that there is a general statement, not limited to a statement about annualised payments, as the court pointed out, all rents, annuities, dividends, and other periodical payments are subject to this principle. And the question is, what exactly is the reach of the principle? Now, Mr. Siegel seeks to meet the court's accusation, the Court of Appeal's accusation, that it was inherent in his case that there was a principle of equal daily accrual by saying, well, not so. In his example of the rate which changes after 6 months, and is rate A in the first 6 months, rate B in the second 6 months, he says, well, of course, he would not contend that it's 1/365th of the total for the year. Now, inherent in that is an acceptance that the contract determines what sum accrues.
Well, it's bound to determine what sum accrues in the sense that it tells you what your pay is.
Yes.
Then
I'm happy to go. I'm going to take it in stages, but the first point is, therefore, Mr. Siegel is not submitting, as I think you're saying, Ms. Hale, and Mr. Siegel's apparently nodding, that in every case, the amount which accrues will be an equal share of the payment over a set of equal installments of the payment over a given period of time. Because the question will be, what is the position under the contract? Now, if that is so, if you're entitled to look at the contract to decide what the rate is in the first 6 months, and then to decide what the rate is in the second 6 months, there is no reason in our submission why you cannot conclude that if the contract provides that on a given day, or that in a given week, there will be no pay, what accrues, there's equal frequency of accrual, but what accrues on the days where under the contract nothing is payable is nil. And hence we would submit entitled to argue that if this contract provides that over the course of an academic year, there will be days on which you're entitled to a particular payment and days when you will not, Saturdays and Sundays, then the Act does not require that any sum actually accrues on the Saturdays or the Sundays, although the Act accepts that in principle there could be a claim for such a sum if the contract provided for such a sum to be paid in attributed.
I thought we were looking at Section 2 on its own. Aren't you really slipping into a Section 7 contrary stipulation argument?
Well, Mo, that's I agree. As the Court of Appeal said, there is an interrelationship for the purpose of construction. You've got to keep an eye on Section 7, and you've got to keep an eye on Section 2, and you've got to decide, I accept, what is the effect of Section 2, and then ask, well, if that is the effect of Section 2, what is the effect of Section 7? If I can put it in colloquial terms, the Court of Appeal effectively said there's a trade-off. So if the conclusion is that the Act does more than simply provide that in principle a sum may have accrued under the contract, if it does more than that, then an express stipulation that there shall not be equal accrual on each day will exclude apportionment, because you're understanding apportionment in a particular way and the contractual terms are fundamentally inconsistent with it. If, on the other hand, you conclude that Section 2 has a much more limited role, it's simply rendering entire obligations divisible, then what you're looking for under Section 7 is something which says we've agreed that there really are entire obligations in this case. And so I accept as a trade-off, my respectful submission is that the better view may be the view that the Court of Appeal came to, which is that actually the Act performs quite a limited role, and that is why Section 7 appears to place a more onerous requirement on those who would wish to contract out of it.
Isn't it clear from Section 7 that it's an all or nothing provision? You either exclude the 1870 Act altogether or you don't.
Well, that's my...
Pretty obvious, isn't it?
Well, well, my answer to that is the Court of Appeal's answer. Was grateful to be in Lord Justice Elias's company. That it depends on what you mean by apportionment. Yes, if apportionment merely means that in principle there's daily accrual, the accrual on calendar days, the frequency is daily, then you're looking for a particular form of exclusion under Section 7, which is basically nullifying that position. But if apportionment has a wider meaning, it doesn't just deal with frequency, it also deals with rate, then to say there should be no apportionment embraces the idea that there shall be no apportionment in equal shares. That's the Court of Appeal's position, and I respectfully adopt it. Now, as to what's the right answer, my submission is I'm going to run both arguments, but in common with the Court of Appeal, I would submit the better answer is that Section 2 has a very limited role, and the rest is left to the contract. Now, it's dangerous to engage in hypotheticals, but can I just give you another example of where we would say a contractual approach, which is how we characterise our approach, would achieve a sensible answer? You might well have a job in the school context where an individual was employed as a gym teacher Monday to Wednesday, but as a classroom assistant Thursday and Friday. And there were different rates of pay under a national agreement for gym teachers as compared with classroom assistants. And that individual's salary was a total of the pay calculated in that way. Now, it would appear that if you say there's an annual salary payable in monthly instalments, Mr. Siegel will say, well, then there must be equal shares, 1/365th. We would submit that a proper analysis of the law ought to permit the court to say that if the strike was on a Wednesday, i.e. a day when they ought to be working as a gym teacher, then the deduction should be at the gym teacher's rates. If it's a Friday when they're working as a classroom assistant, then it ought to be feasible to deduct at the classroom assistant's rates. And that's why we say this question, the amount which accrues, ought sensibly to be left to the contract.
Well, in one sense, it's got to be left to the contract. Otherwise, you simply don't know what it is that is accruing from day to day and what it is that you're apportioning accordingly. And as I understood Mr. Siegel's argument, I mean, that's just self-evident that the contract has to say what the money is that you're dealing with. But as I understood Mr. Siegel's argument, he will tell me later if I got it wrong.
Not much later.
No, not much later. He was saying the contract might also provide for the period over which the sum was to accrue, as in the 6 months at one rent and 6 months at another rent, but indeed also in certain contracts of employment that the money only accrued over the period, a particular period of the employment working time. Where he disagrees with you is he says that's not how this contract works.
Well, there we are. I mean, to that extent, there may be common ground on the analysis of the law. I've made myself...
I'm struggling to find out what, other than your different interpretation of what this contract means, is the difference between you.
Well, that's a question you may want to ask Mr. Siegel. I can, at the moment, from the point of view of reasoning, I don't detect any difference between us on the analysis of Section 2. We appear to be agreed that it determines the frequency and the contract determines the rates. So the question then is, under the contract, what sum was attributable to the strike day?
Can I just ask you a question which may not be quite on this point, but the salary is paid on an annual basis, right? In this case, or in one particular case, £38,241. Now, when we come to... and then if you do in the whole of that period, you do one day in which you're asked to work on a Saturday, which would enable you to have another day's pay on the face of it. How does that affect the £38,241?
It's added to the 38,000.
It's added.
That's right. It's 1/195th of the rate for the work that you do on the Saturday is added to your annual salary.
Yeah.
That's part of our submission. That
Annual salary is actually an example, isn't it? Another example, there are plenty of others, you've given us some, where the rate may vary over the period. Sometimes you get backdated pay rises.
yeah.
Yep.
So now, Ms. Lady Hale's intervention timely as always, because I was going to get onto the point about annualised periodic payments, because Mr. Siegel seeks to answer the six-month question by saying, well, it's obvious this is all about annualised periodic payments. Now, I've already made the point that Section 2 isn't about annualised periodic payments, it's about all periodical payments. And so there are immediate practical difficulties if Section 2 is to do more than divide up as a matter of principle periodic payments and say that they fall due on a daily basis. And if I can point straight away to an immediate practical difficulty in the present case, Mr. Siegel says, well, of course you'd be doing it by reference to the annual salary. But why so? Why not the monthly salary? Because in terms of entire obligations, I don't think Mr. Siegel is saying that unless you worked the full academic year, you were not entitled to your year's salary. As I understand it, he's saying you needed to work the full month in order to be entitled to the month's salary. Now, if one is then concerned with equal divisions over a specified period, one ends up with different daily rates of pay according to which month of the year it is. Obviously, you're paid more per day in February and less per day in January because the denominator is greater in January. So with respect, it just isn't as simple as saying, oh, well, it's all to do with annualised payments. And my practical point, again, points to the idea that all this is doing is rendering entire obligations divisible. Can I turn then to, just given the time for your reference, the point that I make isn't an outlandish point. It's the point that came up in the BCCI case decided by Mr. Justice Evans Lom. I don't take you to it at this stage because of time, but it's in the non-core volume at tab 11. And the issue was indeed that the question was, what should the individual be paid in the last 3 days before the liquidation? And the liquidators were arguing you divide it, you go month by month. And the employee was arguing you do it according to working days, and the court said you go month by month. Then if we make, I'll make my submissions briefly on section 5. That's at page 398. Mr. Siegel appears in his printed case to be submitting that the difference between the difference between dividends and payments under section 2 is that payments under section 2 are going to be annualised payments, and I've made my point about that. Perfectly fairly, he raises the question, well, why would there be a different approach in the case of dividends? Why would that be a special case? That we answer by saying that obviously dividends are earned at a different time to the time when they're declared. They may be held over for tax reasons and so on, but most importantly, a given dividend is not payable pursuant to an instrument which identifies what will be payable in advance. So that what you're concerned with is a fluctuating picture, moving timeframes, and no instrument which identifies when payment will be made or what payment will be made. And therefore, in that special case, the definition of dividend is providing that you do it retrospectively. The payment has been made. The question is to what time what period of time does that relate, and you then divide the dividend by equal daily instalments over that period of time. That we would submit is not seen as a potential issue in relation to other periodical payments, where it's likely rents, annuities, dividend special provision, that the instrument will identify in advance when the payment will be made and how much the payment will be. So those are our submissions on section 5. And I've made the point in answer to Lord Gill's perfectly fair question. What's the interrelationship between this submission and section 7? I adopt the Court of Appeal's analysis that if section 7 is to be read strictly, it must be because the 1870 Act has a limited effect. And finally, we submit that this analysis of section 2 is consistent with Miles and Wakefield for the reasons I suggested in opening my submissions. Sorry, there's one, I said and finally. There's a further and finally. And Mr. Siegel appeared to be accusing us, in relation to this point, of trying to adopt a construction of the statute, which I think he said was many centuries old, and by analogy with the Marks and Spencer case, to say, well, you just can't do that. My respectful answer to that is, there is no principle, many centuries old or otherwise, which decides that the statute identifies the amount which will accrue as opposed to the frequency of accrual, rather than the contract deciding the amount of the accrual. So this isn't a case where the Court of Appeal all of a sudden is trying to change the direction of centuries of analysis of section 2.
But there is a strong line of authority that section 2 means equal calendar daily accrual.
My Lord, again, I'm very grateful for the opportunity to clarify our position. The way I would put the position, which is materially different to the way that you put it to me, is that it's true that there are various cases where the result has been equal daily accrual.
Calendar daily accrual.
Well,
because if you just say daily, then the question is, which days?
thank you.
If you refer to the calendar, we've got a bit of clarity.
Thank you. I'm not seeking to argue, as I said in answer to one of your questions, that on the question of how section 2 operates, section 2 is referring to anything other than calendar days. I accepted that. What I said was that what happens on each calendar day is that in principle a sum accrues, the contract then determines what accrues. That's point 1. Point 2 is, or question two is there a centuries-old principle that not only is there accrual on calendar days, but there is an equal amount accruing on calendar days? My submission is that there isn't. And that's what I thought my Lord was asking me about. What I accept there is, are cases where that has been the result. But if one asks why that has been the result, the answer is because the contracts in those cases did not point to a rate of accrual other than equal accrual. And Lord Justice Elias said this, that of course there'll be many cases where the result is equal accrual in terms of amount. But where there are cases where the contract indicates otherwise, that will not be the result. Can I turn then to our submissions on section 7? Now, again, you've got our submissions in writing, so I'll take my arguments quite swiftly. The first point, again made by the Court of Appeal, is that under section 7, what the respondent in this case needs to prove is the negative. So we need to show, as we would submit, that the agreement excludes the Apportionment Act. So it's a question of incompatibility, as we would put it. Second, we accept, because the section says so, that there must be express stipulation. Tyrrell term so clear as necessarily to exclude apportionment. Joel's will trust necessary implication from the language of the provisions. But we submit that that is the position if the court, through a process of reasoning, concludes that the agreed position of the parties is inconsistent with the result required by the Apportionment Act, then through interpretation of the express terms, the conclusion is that it has been stipulated that no apportionment shall take place. And so, coming back to, I try not to repeat myself, but coming back to the questions I received from the court, if the conclusion is the parties, if the position under section 2 is the statute requires equal daily accrual, and the conclusion is that the parties have clearly agreed that there won't be equal daily accrual, then the result is that they've expressly stipulated that no apportionment shall take place. Now, we don't shrink from the proposition that the test is a strict one of necessary implication, but we say that is the result for the reasons that I sought to advance after lunch in relation to the analysis of the contract. Now, one sees the difficulties of that submission. The Court of Appeal pointed them out, and that's why the preferred analysis from this side of the court is the analysis of section 2 that I was advancing, that actually the Act has quite a limited effect, and therefore section 7 is very rigorous as to what must be required to prevent that more limited effect. Now, again, coming back to questions of the justice or injustice of it, hypotheticals and so on, Mr. Siegel's position is that even in a case like Cooper, it wasn't clear enough for section 7 to bite. So a clear agreement for a 37-hour week. And in my submission, that's surprising. He's therefore obliged to submit that Cooper is wrongly decided, unless he accepts the analysis that we propose under section 2. Now, I've then got a section headed hypotheticals, despite identifying the danger, especially with such a clever court, in jousting over hypotheticals. So I'm going to take that section fairly swiftly, but take the point about the teacher who's on strike Monday to Wednesday, and of course potentially throughout the term if the industrial dispute can't be resolved. The calculations do show that in that situation, according to Mr. Siegel's submission, they would be entitled to 68% of their pay. And we would submit that it's not a crude characterisation by the Court of Appeal to say that actually they haven't done 60% of the work. Now, Mr. Siegel's answer to that is say, well, actually, they will have done the work at some point. But what reason is there to suppose that that's the case? It may be true in the case of one day of industrial action that everybody will catch up. But I made the submission that these propositions have to be tested against more serious industrial action. And Mr. Siegel says, well, it's a controversial proposition that they would call in a supply teacher. In my submission, it can hardly be a controversial proposition that if during a term time, for example, the history teachers were not teaching Monday to Wednesday because they're on strike, the college would make provision for a supply teacher to be brought in, so the work would be done by a supply teacher. And by the way, the supply teacher would be paid at the rate of 1/95th for the days that he or she worked. So the more extensive industrial action example in my submission does point up problems with my learned friend's analysis. I've dealt with the position on undirected time. Can I just see whether there's anything else that I want to do? Yes. On undirected time, the point has been made against us that it's surprising that we're accepting that we would not necessarily be able to deduct pay for a teacher who wasn't doing any sufficient undirected time. Mr. Siegel appears to be contending that in fact the college would be able to do that, although there'd be mind-boggling difficulties of quantification. But if it's right that a teacher who, for reasons of industrial action, says that they're not going to do undirected work, can have pay deducted, it must also be right in my submission that a teacher who decides that they will never work on a Saturday can have their pay docked by the college. Now, ironically, the logic of Mr. Siegel's position is that we could do that. The college's position is that it couldn't, because it's not paying for work on Saturdays. Can I also invite you to consider, or when you decide the case, wider other examples on how the respective positions of the parties work. If one has a contract that provides for an annual salary of X to work for 5 days a week, payable monthly, my understanding of Mr. Siegel's position is that they're still working at 1/365th per day, and that if they refuse to work on a given Monday, that's all you deduct. In my submission, that's a surprising proposition if that is the case that's being put forward. Can I also invite you to consider the position of part-timers? What is the position if a part-timer provides their work 1 day a week, they work on Mondays, and they take industrial action, which is essentially they don't work on Mondays, they strike on a Monday and therefore do no work in the course of the month. Now, as I understand Mr. Siegel's position, although they've effectively not worked for a month, you can only deduct 4/365ths of their pay. Now, Mr. Siegel asked the question, why would the approach be different as between rent and salary? My position is that it might or might not be different according to the precise contractual arrangements. But one can immediately see reasons why the approach might be different in the rent case. If rent, you're paying to occupy premises. Under a contract of employment, you may or may not be working on a given day of the week, and therefore may not be being paid to work on that particular day. So there's no particular reason in my submission why the approach to rent and the approach to salary would need to be the same subject, of course, to the particular contractual arrangements. So if, for example, a teacher rented a flat for weekdays and the owner of the flat occupied at the weekends, it would be our case that the rent was attributable to the 5 days. It would appear to be Mr. Siegel's case that the rent is attributable to the 7, although they're not occupying at the weekends. If it were the case that they worked all 5 of those days, it would be our position that their salary was attributable to each of the 5 days. But if they only worked 4 of those 5 days, it would be our position that it's attributable to 4 of the 4 days. Again, Mr. Siegel's position would be it doesn't really matter, that it's still 1/365th. Now, the next heading in my submissions is we also rely on. I'm going to take that swiftly because obviously what matters is what this court makes of the Court of Appeal's judgment. But we do rely on the decision in Cooper and in Amy, both of which my learned friend, we would argue, needs to submit are wrongly decided. And we draw attention to the decisions of the Employment Appeals Tribunal in McConaughey and then in Yarrow. Can I just give you the references for those? McConaughey is in the non-core volume 2, tab 20. And Yarrow is non-core volume 2, tab 34. Now, of course, what the Employment Appeals Tribunal says may not be of the greatest significance to this tribunal, but, and I don't say that the analysis necessarily in those cases was correct, but what happens in those cases is that the Employment Appeals Tribunal, firstly in McConaughey, sitting with lay members, is very surprised by the idea that you would divide pay on a 1/365th basis because they took the view that it's obvious that salary is 4 days of work. And of course, the result of that analysis had the advantage that it meant that holiday pay was greater than it would be if you adopted a 1/365th position. Now, obviously, those are far from being powerful authorities, given the arguments that we're having, but you can see the industrial, we say there is industrial reality to the analysis we're offering, that it's essentially saying we pay you to work, we pay you for holidays, we don't pay you for days when we specified that you won't be working, and that if we ask you to, we'll have to pay you more. My learned friend relied on Smith against Kent CC, which is tab 15 of the core authorities. Our submission, we make various points about that in our written case. Mr. Siegel is drawing heavily on paragraphs in that judgment providing statistics about the extent to which teachers work outside teaching hours, and we've suggested in our case that you need to be cautious about that. Statistics from the secondary school sector in 2004 in a different contractual context. The question has been asked, why was no agreement reached in the present, under the Red Book, if agreement was reached under the Burgundy Book? Mr. Siegel answered that question perfectly fairly, to the effect they didn't know. It might be because they wouldn't be able to reach agreement. It might be because they didn't address their minds to it. But at all events, you have an express term in the context of the Burgundy Book, which is a particular contract. It is described as being a compromise, an industrial bargain. In my submission, it doesn't assist you to draw any conclusions about the analysis of the contract in the present case. Now, I turn then to the new point, which I seek permission to argue. And without being too presumptuous, I've allowed myself 20 minutes to do that. Can I?
Slightly under 20 minutes.
Well, yes, that's sorry. I was inaccurate. 18 minutes. So may I spend a minute of them seeking permission?
Why don't you just get on and argue it?
Thank you. That's what I
We
would very
will
much.
either forget it or not, as the case may be.
Thank you. That's what I'd very much like to do. Now, firstly, can I remind you of the nature of the new point? Because possibly more heat than light is generated in the written exchanges between the parties on this topic. The nature of the point involves the proposition that the Apportionment Act bites on entire agreements or contracts where there are entire obligations so as to render them divisible. And then secondly, the submission is made that this is not a contract that involves entire obligations. Mr. Siegel, shall we say in trenchant terms, not always 100% polite about our written case, accuses of trying to rewrite the common law. I would never be so ambitious as to attempt to do so.
Oh, people do that round here all the time.
That's exactly what I was going to say.
Well, I'm not trying to do that. Certainly disavow any attempt. The common law, we accept the common law principle that where the contract provides for an entire obligation, that obligation must be performed if payment is to fall due. And we accept that the Apportionment Act then modifies that position. We raised the prior question whether, on the true construction of these contracts, they concern entire obligations, as to which we submit there is no common law rule or presumption. The common law position is, as you'd expect, that the question whether there is or isn't an entire obligation is a matter of construction. That's the essential nature of the argument. Now, can I then seek to develop that argument in the 14 minutes that I have left of me? The first proposition has to address the position under the Apportionment Act. Is it the case that the Apportionment Act is simply concerned with rendering entire obligations divisible? May I ask you to take up tab 1 in the Court Volume of Authorities. Our submission, adopting the analysis of the Court of Appeal, is that that is precisely what the Act intended to do. We rely firstly on the preamble, referring to the position at common law and seeking to address it as part of the mischiefs at which the Act is directed. And we point out, by reference to, for example, Section 3 and Section 4, that it is clearly contemplated in the workings of the Act that there are entire obligations under the contract. So if we look at Section 3, which raises the question, all right, so the entire obligations become divisible, but when does the divisible sum fall to be paid? And the answer is at the time when it would have been paid under the entire obligation. So you can see references in line 2 to when the entire portion of which such a portion part shall form part becomes due and payable, and then reference to when the next entire portion, and at Section 4, again dealing with issues of division of entire portions. So we do submit that as a matter of literal construction, from which Mr. Siegel urges you not to depart, the position is that the Act's clearly directed at entire obligations being and rendering them divisible. In support of that proposition, although there's not time to take you to it, we rely on Professor Glanville-Williams's article, tab 17, MS 675, Moriarty, or Authorities, tab 12, MS 579, and Fasihi, tab 8, at paragraphs 100 and 116, 5 and 6. If that proposition is right, then the next question is whether the present contract is one which gives rise to entire obligations. We submit that that is a matter of construction, and here Mr. Siegel agrees. Paragraph 86 of their printed case, they say in terms that whether a payment is divisible is a matter of construction. Next question, is it the case that where a contract provides for an annual salary payable in monthly instalments, which is this case, Mr. Siegel says payable in arrears, but the contract doesn't use that terminology. You've seen clause 2.1, I think it is, clause 4.1. Is it the case that in that type of structure, there's a common law rule or a common law presumption that the contract gives rise to entire obligations, that you don't get a month's pay unless you work the full month? Or possibly, I suppose, unless you work the full year. Our answer to that is no, that there is no such common law rule or presumption. In giving that answer, we recognise, as I put it earlier in exchanges with Lord Wilson, that there are cases where that's the result. So Mr. Siegel is perfectly entitled to point out that that was the result in the Healy case, 4 volume tab 5, that it's what was said by Mr. Justice Scott in Sim and Rotherham as the result in that case, and that it was the outcome in Fasihi. But we submit that a reading of those decisions demonstrates that the court wasn't calling into play, in interpreting an annual salary payable in monthly instalments, a common law rule or presumption. Certainly in Healy it appears, and in Sim, either there was an argument about it, or it was said, but it wasn't central to the resolution of the dispute. Sim wasn't a case about deciding the position under the Apportionment Act. It was the issue in Sim was, do teachers have a contractual obligation to cover for each other? And in none of these cases was it the position that alongside the essential structure of an annual salary payable in monthly instalments, there was a series of, as we would characterise them, countervailing contractual terms which tended to indicate that you were paid for working days, so that if you did a working day, you were entitled to be paid for it. So time doesn't permit me to take you through all of those authorities. You may be relieved to hear that. And of course, it may be that,
Well, you've referred to some authorities
Yes.
that go the other way, but you say when you drill down, you don't find an analysis of the common law. But what are the authorities that go your way?
well, I don't need authority other than to say, well, for example, I mean, let's Cutter and Powell, to say that the question is one of construction, with which my learned friend doesn't disagree. So what I characterise those cases as where that may have been the result, or what the court said. But crucially, because I'm going to come on to Marx and Mr. Segal again saying that we're trying to rewrite the common law. Importantly, we're not trying to rewrite the common law. We're agreeing with the common law that it's a matter of construction and pointing out there is, as we would submit, no common law rule or presumption which we're seeking to abolish, modify or rewrite. And so we say, I've made my submissions I shouldn't say effective, but I made my submissions, broadly speaking, in writing and then orally as to why this is a contract which is essentially an agreement that you get paid for term time days and for holidays. And that if dispute arose about it, you'd be entitled under the contract to pro rata payment. Now, that brings me to the Marks and Spencer case, which again, I'm afraid I'll just take, if I may, in headline form. Mr. Segal, quite rightly and eloquently, seeks to argue that we're just doing exactly the same as was attempted in Marks and Spencer's unsuccessfully not very long ago. The important points we would submit about the Marks and Spencer's case are, firstly, that there was a clear common law rule that there would be no apportionment of rental payments in advance. Secondly, there was clear, shall we say, dare I say it, centuries-old authority, Ellis and Rowbotham, which said that the 1870 Act did not provide for apportionment of rents payable in advance. So the 1870 Act hadn't changed the common law. Thirdly, the case was concerned with commercial agreements drafted by lawyers and not unnaturally faced with an argument that there was an implied right of apportionment. Lord Clark knows the case, obviously. The Supreme Court said, well, the lawyers who drafted these clauses will have drafted them on the basis of a particular understanding of the law, of the common law, and of centuries-old authorities to the effect of the Act. And so it would be wrong now to be implying a term which was actually contrary to the common law position and contrary to the Act. And certainly you couldn't say that the parties would necessarily have agreed a position contrary to common law and contrary to statute. So, in our very respectful submission, none of that's surprising. But compare and contrast the present case. We do not seek to, this is not a process of implication of terms, where, as the court also knows, the Marks and Spencer case confirmed a strict approach, a test based on necessity. Ours is a case where we rely on the construction of the express terms. Secondly, it's not a case where the construction argument is conducted against the background of a clear common law rule and clear and binding authority to contrary effect in relation to the 1870 Act. Our case is simply based on the construction of the contract. Now, as to that point, Again, there doesn't appear to be a great deal between Mr. Siegel and I on this. He spent a lot of time saying that our analysis of the Deakin article was misleading, doubly misleading, and we went as far as to say that. But the important thing is that he agrees that the modern contract of employment, as Professor Deakin identified, essentially came into existence in the mid-20th century when statutory employment protection really came into its own, began to really come into its own. So we, as a matter of construction, it appears that the parties agree that it's permissible to construe the contract against the background of the modern contract of employment, against the background of modern statutory employment protection. And in that connection, we rely on the case of Smales against Lee. That's non-core volume 2, tab 28, MS 1327, paragraphs 42 to 43, where the Court of Appeal said that a contract for the provision of surveying services had to be construed in the modern context. Time doesn't permit me to take it to you, but we take you to it, but it's referred to in our printed case. So hence our submission that construing this contract in the modern context against the background of statutory employment protection, which provides all sorts of rights in relation to paid time off, days of time off, days of holiday, and so on, coupled with the terms of the contract itself, on its true construction, this is a contract which provided that you were entitled to pay upon completing a working day's pay or at the end of a particular holiday day. It's not a contract which we submit required you to work the full month before you had any entitlement, or still less the full year. Ultimately, I've reached the end of my time, and those are my submissions.
Thank you very much indeed, Mr. Linden. Mr. Cooper? Mr. Siegel.
Can I first, if I may, just deal with strange facts? One of the dangers in running this new argument, if you're allowing it to run, is that certain facts are taken as assumed or agreed when they're not. But I confess I hadn't realised the extent to which the agreed facts were not agreed. Can I just remind the court of what the agreed facts were, which they looked at page 43? The appellants regularly performed their undirected time duties outside of normal term hours because there was not time to perform them during, I abbreviate, directed time. So the first agreed fact is not, as my learned friend suggests, that it all depends.
Sorry, which paragraph are you in?
2.4, page 43.
Thank you.
And then if you glance through, Mr. Hartley, every weekend of the year, Saturdays and Sundays, Mr. Pankow, weekends, Mr. Monk, 25 to 52 weekends a year, and at the bottom, in the evenings, at weekends and during the holidays. So absolutely in answer to two of the questions that were put to my learned friend, yes, they had to work on Saturdays and on Sundays. The lesson marking, the lesson plans that they are describing as, for instance, Mr. Monk having to do on those Saturdays and Sundays, they are, as we've seen, part of the teaching duties, part of the core duties. They are things that have to be submitted to the college. Indeed, they're assessed by Ofsted. And if they can't be performed during directed time, then to suggest that they're not part of the duties for which the appellants are paid seems odd. And the only way my learned friend seeks to get around this and I don't know if he did this deliberately or not, I suspect not, but 3 or 4 times in this passage of his submissions, he referred to the difference between directed duties and undirected duties. As I say, I suspect it was just a slip of the tongue, because, of course, there is no such distinction. There is a distinction between teaching duties and other duties. When you perform them, on the other hand, is a separate issue. And again, I don't know if this was, well, it must have been deliberate, but when Lord Hughes asked my learned friend whether, in fact, he was saying not that one is paid for the duties one performs in directed time and not for the duties one performs in undirected time, but rather that the payment is just not allocated to days other than Monday to Friday, I believe I heard, and certainly wrote down, my learned friend said yes, that is indeed what he's saying. But that is a very different case to the one that at least I read in the respondent's printed case. And it would be a yet further step away, we say, from reality. So if we're accepting, as the answer at least to that question accepted, that Mr. Monk is paid for all those duties that he does in his directed time and in his undirected time, why should one presume that the pay he receives at the end of the month is allocated only to the duties he performs during his directed time? I remind, again, unfortunate this, that it is a new fact relied on as part of the new case and rebutted for that reason. But I remind the court that Mr. Hartley's additional work was additional undirected time work. And that's what he's paid for. Now, you won't get that from the documents. That's on instructions, although one might see it as an inference given that he's doing it during the holidays. But if this new argument wasn't a new argument, but had been raised in the defence, let's say, we would have had evidence to that effect. And in answer to, I think, 2 of my Lord's questions in relation to, well, what about someone who works on a Saturday, takes the students on a sports trip, for instance? My own friend said, oh, well, he'll be paid extra for that. Not so. The directed time is a certain number of hours which can be spread over a certain number of days, including, as you see from the contract, in the evenings, though not more than a certain amount, and including on Saturdays. It cannot, paragraph, I think it's 56, says it cannot be allocated onto a Sunday or a public holiday, but it can and is often allocated onto a Saturday. So the idea that the pay is only allocated onto Mondays to Fridays makes even less sense. I agree, of course. If, as well as the 195 days, the teacher is asked to work 100 and do, I don't know how much more work, some of which will be on a Saturday, then yes, they'll be paid more. Indeed, whether it's on a Saturday or a Friday, as Mr. Hartley, they'll be paid more for the more work. But there's no distinction as between day in that regard, although, of course, as a matter of practice, nearly all the directed time that teachers who don't take sports trips are responsible for performing will be Monday to Friday, because that's when the college opens its doors to all its students. So when it is said that our case is that if a teacher said he wasn't going to work on Saturdays, he would be, he should suffer deductions. Absolutely not. We've said not in writing twice, and orally before lunch. If the Saturday was a directed time day, if the teacher said, I know that I'm being paid to take these children to a rugby match, and I'm not going to do so because I am on strike, yes, of course a deduction, just as if it was on a Tuesday. But that's because he's not doing work that he is contracted to perform. But if a teacher said, I'm a Jew and I don't believe that I ought to be working on Saturdays and I refuse to work on Saturdays, but I'm going to do all the work that you asked me to do in directed and undirected time, Do we say that he should suffer a deduction? Of course not. The gym teacher, the support assistant, again, new facts. I would have thought, personally, that someone who had responsibilities as a gym teacher and also responsibilities as a support assistant would almost certainly have 2 contracts. I can't imagine a single contract that says you will be one thing Monday to Tuesday, another thing Wednesday, Thursday, Friday. But I don't know because it hasn't been explored. But if it is the case that they'll have 2 contracts, they're in no different a situation to that part-time teacher who teaches the first 2 weeks at one college and then goes off and teaches another 2 weeks, or perhaps opens a shop for the other 2 weeks. Can I just deal with the principle of equal daily accrual? We do not say, as was pointed out by the court, that what the Court of Appeal have characterised the principle of equal daily accrual, not a phrase that of course appears in the legislation, must apply in every case, and particularly those rare cases, such as the Court of Appeal contrived at paragraph 37, where the contractual consideration changes during the relevant period. But we do say that in the case of annuities, including annual salaries, the annuity accrues equally every calendar day. And my learned friend is right. Section 2 does not just deal with annualised payments. We've never suggested, contrary to the implication, that it does. But it does include annuities. And Section 5 deals with
Annuities does annuities mean something paid annually, or does it include any salary which might be paid monthly?
Well, an annuity before 1870 was not, I shouldn't say this as though I'm entirely confident, but I believe did not include salaries. That's why in 1870 salaries were included. I'm afraid I haven't gone back to check that. So an annuity would be what we all understand normally to be an annuity, that is to say, an asset which is realised on an annualised basis and payment made either annually or quarterly or monthly or whatever to reflect the annualised amount due to the beneficiary. A contract of employment for a salary paid periodically is simply a subcategory, since 1870 at least, of such an annuity. And when Section 5 is dealing with the bit that my learned friend and Lord Justice Elias rely on, it's dealing with a subcategory of the Section 2 cases, not annuities, obviously, expressly, but dividends. And yes, my learned friend's right, they operate on a different basis, hence the, for avoidance of doubt, provision in Section 5. Can I just deal with a few points on Miles and Wakefield? Because my learned friend's submissions skillfully imply, though to be fair, do not state, that the House of Lords gave any consideration at all to the quantification of the claim. They did not. The issue in that case was purely and simply that a deduction had been made, and the claim was you had no right to make any deduction, therefore it should be repaid. There was never even any discussion of whether, if there were to have been a lawful deduction, it should be 3/37ths or 1/7 or 1/365th or anything of that sort.
Well, except in Lord Templeman's example
I was going to...
the ambassador and the judge, and it's 1/365th, and the doorman, or whatever, the other two, where it was a fraction of the working day.
My lady anticipates the last of the 4 points I was going to make, which is that when, I'll now make it out of order, my learned friend took the court to that part of Lord Templeman's judgment and said, I suggest somewhat boldly, that it supports their case, because he says it shows that it all depends on the contract. Of course, he avoids facing the fact that Lord Templeman said that in the case of a judge who then, as now, was not expected to work 365 days a year, the appropriate apportionment was 1/365 and not some other number. But can I just at least give you the references at these are the internal page numbers. So electronic page 545 but just around E in the speech of Lord Temple, you'll simply see the statement of what was deducted. That's the only, this is just in setting out the facts, and there's nothing there to indicate that the quantum of it was in dispute per se. 570, electronic page number 561, within Lord Oliver's speech between D and E, of course, as my learned friend read out, all that's said is, as to quantum, that it is all subject to the question of whether the wages or salary payable are apportionable on a periodic basis. And finally, at 576, the very last page of the judgment, 567 of the electronic bundle, Lord Oliver refers to remuneration attributable to the work and leaves open the question of what would be attributable to the work. And as Lady Hales pointed out, the only person who actually addresses quantification at all is Lord Templeman, and says that as to someone who may be required to work, as Mr. Justice Blake put it, on evenings and weekends, it should be 1/365.
In our case, the salaries were assessed annually, were they, but paid monthly?
Sorry, I didn't hear.
Were they paid monthly?
In which case?
In our case.
Yes. Yes.
So if you did 1 day's directed work on a Saturday,
Yeah.
you'd be paid extra that month, would you?
If it was extra work, you're paid to do an annual amount of
Yeah,
work.
but assuming it was.
Yes, you would be paid.
You'd be paid in that month.
I
Or do we not know?
assume so, but I don't know.
Right, okay.
I assume so, yes. But I'm afraid I don't know. So, dealing with the new case, I do rely, I really do rely, not just as a matter of form, on what we say as to why permission should not be granted. This is a new argument involving considerable variation to the case we've had to meet, and it involves withdrawing a concession. I'm quoting in each case from the cases, a concession that formed the basis of argument and judgment in the Court of Appeal. It does seek to displace a common law rule. I'll have a little more to say on that, which has been settled for well over a century. And also, in discrete but significant ways, it does presume evidential matters which haven't been properly explored. But having said all of which, it's been argued on paper and for 18 minutes, so I'll try and respond to it briefly. First of all, one must bear in mind that Lord Justice Elias, in this case, although the point wasn't taken, took it upon himself, helpfully from our perspective, to address it as though it had been taken. And at page 151, within paragraphs 23 to 32, he addresses this issue from first principles and decides it against the case as now put by the respondent. He notes the definition at paragraph 24 of an infinitely divisible contract in the famous article by Glanvin Williams. At paragraph 25, he distinguishes these contracts because they provided, I quote, for salary to be paid monthly in arrears. And in doing so, he followed the similar first principle analysis in the recent court appeal case of Fasihi and in the last of those paragraphs referred to Sim, both of which featured broadly the same type of contract. One sees that at paragraphs 30 to 32. And we respectfully say that analysis is correct. So what of the suggestion, this isn't really my learned friends trying to depart from a well-established common law rule. The common law rule that they're seeking to depart from, which is very well established, is that when you have an annualized salary paid periodically, then it is treated as indivisible. And in answer to, I forget which of the court's questions, no, there is no authority against that. Yes, there are many authorities, some of which my learned friend dealt with, Healy, Fasihi, BCCI, Reynolds, Cooper, Sim, Miles, Amy. Yes, there are all these authorities. That's just within the employment field, mind you. that deal with the indivisibility in relation to the common law rule that applies in the employment field. And in none of those cases was the claimant's working time disaggregated as to working days or Mondays to Fridays, even though in all of those cases, the managing director, the sales and managing director, the judge, the ambassador, the teacher, they all worked a basic week, as it were, together with this extra time, and none of them worked 365 days a year. So yes, it is a startlingly new way of looking at things that has not been foreshadowed in academic criticism or law commission reports. It should be politely declined the invitation to depart from that common law rule. The intended scope of the Act, as we've said, is that, as at 1870, a well-recognised group of people, professional and similar, were remunerated by periodic payments of salary, and that the Act was intended to apply to that category of person. Can I now turn to the contractual analysis that my learned friends rely on? Before I do so, there are a couple of short points that they introduce in their written printed case, and one referred to obliquely by my learned friend in oral submissions, and that is what the generalised position is under legislation. My learned friend referred in oral submissions to the working time regulations. The working time regulations are in my Lord's non-core authorities bundle, volume 1, at tab 8, page 923. The relevant part is 928. And may I just quote, you won't perhaps even need to turn it up. Working time in relation to a worker means, and then little a, this is what my learned friend paraphrased or quoted, any period during which he is working at his employer's disposal and carrying out his activity or duties. I'll ignore little b, which is to do with training. Little c, any additional period which is to be treated as working time for the purposes of these regulations under relevant agreement, read contract. Well, we know what this contract says about working time. It's all duties, whether performed in directed or undirected time, and whether at the employer's disposal or not. So yes, from the perspective of health and safety, it's working time. The point that my learned friends raised in their printed case but didn't repeat in oral submissions is perhaps even more interesting. They say in their printed case that the national minimum wage regulations assist them, because there is a regulation there in relation to salaried hours work, which says in passing that one might also have further work on a paid or unpaid basis. Those regulations are in the same bundle, the tab 4, they begin at 827. The key thing to note about these regulations, and it really does in a sense go to the heart of that fundamental principle I said that this appeal engaged, is if one looks at Reg 17 at page 841, there are various types of work, hours worked, that must be brought into account, and one, to be sure, is salaried hours work, and the fourth is unmeasured work, which is dealt with at regulations 44 and 45, unmeasured work, page 856, any other work that is not in the other three categories. And what is unmeasured work, other than so described, if one goes to the previous tab, which you don't have in that tab, but which you were sent electronically and we have copies for you, was in the original version of these regulations given an example that they didn't feel they needed to re-legislate. And the example that they give, it's Regulation 6, reads as follows. Unmeasured work means any other work that is not time work, salaried hours work, or output work, including in particular work in respect of...
Which regulation are you reading?
6 of the new...
Yes.
Of the older regs, the new document.
Yes, quite.
Work in respect of which there are no specified hours and the worker is required to work when needed. So in other words, this undirected time work. And of course, Stepping back from the artificiality of the hypothetically constructed examples to the real world of work and pay, that is, of course, absolutely essential. Because if Mr. Monk were paid 32.5 times £7.20, the present national minimum wage, i.e. £234 a week, then the respondent would be in the clearest breach of these regulations, because when Mr. Monk aggregates his salaried hours and working time and his unmeasured working time to arrive at, let's say, 60 hours, he will find that he's being paid at less than £4 an hour. From the respondent's case, as I understand it, well, it's not as I understand it, as they state it, that's fine. Contractual provisions, holidays. The Red Book says nothing about holidays. The contract provides, as my learned friend has taken you to, and I took you to initially, that you will be paid full salary during holiday periods unless you are receiving less, I paraphrase, due to the application of sick pay, maternity scheme, etc. All that does is reiterate the effect, therefore, of the provisions of the Red Book concerning sick pay and maternity. They are to be found at page 236 to 241. And I say they make it clear that the appellants are not paid for their holidays, and the clearest indication of that is at paragraph 71 on 238. My learned friend took you to part of this paragraph, but didn't follow the logic of it through. If one of the appellants is sick on the last day of term, and that sickness continues throughout his holiday, and if he hasn't accrued enough of an entitlement to full or half pay, he will be paid nothing during his holiday, nothing. And if that happened in all of his holidays, he would receive no single penny under the contract for holidays. Now, my learned friend rightly says or implies that would be unlawful under European-derived legislation in relation to paid holidays. He's right. But the contract makes it clear that you are paid during your holidays, but not for your holidays. And the very passage my learned friend relies on at paragraph 73 is the best evidence of that, that if you recover during the period that the college is closed, you are deemed to have returned to duty. That, we say, is fairly strong support for the proposition that the default contractual setting is that the appellant's annual salaries accrue daily throughout the year. They can be sick during their holidays, they can be sick during their term time. In my learned friend's case, what on earth does it matter whether they're sick during their holidays? Why should their pay be reduced? None of their pay is allocated to that. And when they're on holiday, they're on holiday. They don't have to be well to be on holiday. Returning to the Red Book in relation to periods of other leave, the position is no different to that of a part-time teacher. She is, by specific contractual provision, entitled at the end of the month to a pro rata sum for performing her work that month, sensibly, as we say, calculated pro rata to the readily ascertainable scheduled amount of directed time, or working days, which we note is not the same thing as directed time. It's days when the college happens to be open, or half days even. And if one looks at page 216, where the Red Book begins, and perhaps turns over one page to 217 to the contents page, it's quite instructive to get an overview. My learned friend says there's no correlation between work and pay in this contract. Of course there is. It's in section 1 and section 2. You're paid the annual salary to perform the duties. And if this contents page ended after miscellaneous on section 5, the position would be that any leave taken by a teacher would be unpaid, and their entitlement to salary at the end of the month would, at common law, depend on whether they'd provided substantial performance that month. And that remains the common law position in respect of absence from work for reasons other than those dealt with in section 6 sickness, maternity, paternity, such as, for instance, unauthorised absence. If a teacher was to just not turn up for 2 or 3 weeks, I mean, they might be dismissible, but that's a different question. But if they weren't dismissed, the question at common law would be, had they rendered substantial performance? If the answer was not, then they wouldn't be entitled to say, well, I want to be paid for the 2 weeks I did turn up, please. Similarly with industrial action. But, as my learned friend indicated, over the last 2/3 of a century or so, statute in particular has intervened to provide rights to paid and unpaid leave in several situations. Some of these rights are in fact enhanced in certain contracts, and some of them are enhanced in these contracts by agreement. But the basic rights must be provided, the minimum rights. Hence, Section 6 and Appendices 5 and 6, which are parasitic on them. And the effect of that is to superimpose onto the monthly contractual entitlement to pay corresponding entitlements and obligations to partial pay for a month when the teacher is on leave in specified situations. And of course, that calculation of partial pay is made pro rata to working days, which, as I say, is not quite the same in any event as directed time. And not least because that's what the various statutes actually require. In effect, they talk about days and weeks. And if these contracts had stamped all over them, this is a contract for the performance of indivisible, entire monthly obligations payable in arrears, those provisions in relation to sick pay and maternity pay would still be required and would not serve to undermine that contractual position at common law. It's no different in principle to an 18th century contract for annual hire, which contained a provision that if a worker had a sustained period of illness or gave birth during the year, her pay at the end would be reduced pro rata to the period of sickness or confinement, as opposed to her not being entitled to any pay at the end of the year because she hadn't provided substantial performance. The contract, and this is the point, would still be an entire or indivisible contract. And if the worker walked out halfway through the year, the Apportionment Act not having been enacted yet, she would not be entitled to any pay for the half year she had worked. In effect, the respondent wants the tail to wag the dog. The exceptions in respect of paid leave in particular situations, largely imposed by statute, to the essential contractual position don't subvert that essential position. They never have in the past. The teacher's contracts in SIM, for example, just judging from when SIM was decided, would have had to have included provisions in relation to sick pay and maternity pay. And they should not do so, we say now. And these exceptions, moreover, must be confined to their stated scope. In a different context, I've used this Latin expression before, I use it again, expressio unius est exclusio alterius. These are the exceptions that say when absence is to be treated in a particular way. Industrial action absence in these contracts, as opposed to the school teacher's contracts, are not covered. They fall within the normal common law position. So one steps back to make what I hope are two fundamental and reasonably uncontroversial points.
1 minute.
The respondent has to prove that there's something in these contracts which definitively displaces the effect of the provisions stipulating that their annual salaries are paid each month in return for the performance of their full range of duties. And I noted that at one point my learned friend said, what you have in this contract, I quote, are countervailing contractual terms that tend to indicate. Not the test that Lycett and other cases would have any truck with. And we say that's particularly so, as the President of this court observed in the Marks and Spencer's case, where a party seeks to imply a contractual intention that's contrary to well-settled law at the time the contract was made. The last point, and I'll make it simply without developing it, is that all of this is really the backdrop to the final separate question, which is even if, on the new case, we assume that the salaries of the appellants are impliedly divisible into payments for work during directed time and are therefore so different from the salaries of teachers and other professionals in 1870 that their contracts weren't within the intended scope of the 1870 Act. Even if we assume all that against the appellants, the next question is this. does the application of the natural, literal construction of the Act to the contracts in this case lead to such inconsistency with the purposes of the Act, or to such absurdity, that the court should construe Section 2, all rents, annuities, dividends and other periodical payments in the nature of income, to exclude these periodical payments in the nature of income, and should construe the word salaries to mean, well, what? Salaries for people who are paid to work 365 days a year? So you're being invited, in effect, to repeal part of the Act. We say you should decline that invitation also.
Thank you, Mr. Siegel. Well, thank you to everybody for their submissions, both orally and in writing, and that means to everybody who's contributed to those submissions. As always, it's an extremely interesting point. And as my lord would say, it's probably all comes down to a matter of construction.
Common sense.
We shall go away and try and solve it. The court is now adjourned.